So good evening.
Good evening.
Uh,
Can you see me now?
I'm just seeing. Yes, sir. Perfect.
Thank you.
I, on behalf of Beyond Law CLC, welcome you all, rather all the lawyers from Punjab and Haryana High Court, as well as the district courts. Welcome you. It is always a pleasure hearing you inside the court, outside the court. Mr. Dave is a senior advocate and the president of the Supreme Court Bar Association. He is known for his writing skills, oratory skills. He is called as a speaker on various platforms. So we would like to inform you that Beyond Law CLC was an idea conceived during this lockdown period. We thought that we have watched a lot of movies, we have read a lot of things. Why not engage ourselves for things which could enhance our knowledge, enrich us by hearing the persons who are well known within the professional field, especially the lawyers. And when people like you join us, it gives a different spectrum to the thought process. In this Beyond Law CLC, today's webinar, UILS, that is a 5 years course of law, Punjab University has also joined. They were too pleased and too happy to the effect that you are coming for the keynote delivery. So we have with us today Mr. Karanjit Singh, who is the chairman of the Bar Council of Punjab and Haryana. I will formally ask him to introduce himself. He has been a member Bar Council. This is his second term. He is doing during these trying and testing times a wonderful job. He is looking upon as to how the lawyers who have not been able to make their ends meet, because as you are well aware that all lawyers don't have a roaring practice. During the initial years, there's always a struggling time. Mr. Karanjit is a wonderful person besides being a chairman and a very established lawyer. Over to you, Mr. Karanjit.
Good evening, everybody. Good evening, Mr. Vikas. Are you hearing me?
Yes, you are audible.
Okay. Good evening, everybody. In the present extraordinary situation when the whole world is in lockdown, Beyond Law CLC is a nice initiative by a group of advocates and professionals and law students organizing series of webinars. I congratulate Mr. Vikas Chitrat and his team for this initiative. They have organized to date around 25 seminars. And today the topic Future of Arbitration, and the keynote speaker Mr. DUSHYANT Dave, senior advocate, president of Supreme Court Bar Association. I welcome you, sir. In this seminar, I also welcome Dr. Ratan Singh, Director UILS. I also welcome all the participating advocates and students. In the present scenario, when the world is in lockdown, organizing the seminars and enlightening the young advocates and giving them a new enlightenment of the various fields of law. In the Bar Council of Punjab and Haryana, we have also started this series of seminars. And on 7th of May, we are organizing a seminar on the topic of law in digital age and Indian legal industry transformation. And on that seminar, I will again have Mr. DUSHYANT Dave as the keynote speaker. Mr. Dave is a senior advocate practicing in the Supreme Court in India at New Delhi. Mr. Dave has been at the bar for 3 decades, during which he has appeared in several thousands of cases in High Court and Supreme Court of India. Mr. Dave's field of practice is extremely wide and involves various subjects like constitutional law, administrative law, civil law, corporate law, substantial work in arbitration law. Mr. Dave has appeared in many celebrated cases resulting in widely known decision of Supreme Court. Mr. Dave has been appointed MSQ by Supreme Court in matters involving substantial public interest. Mr. Dave has a vast experience as counsel in commercial arbitration, both domestic and international. And today's topic, future of arbitration, we could not have a better speaker than Mr. Dave. He has been nominated as the Director of Board of American Arbitration Association 2008. Mr. Dave is the former Vice Chair of the Arbitration Committee of Interested Bar Association. So I again welcome everybody here in this seminar, and I must congratulate Mr. Vikas Chitrat for this good initiative. And I wish good health, good spirits to everybody. I again welcome everybody. Thank you very much.
Mr. Karanjit, thank you. And we also have Mr. Ratan Singh with us, who is the Director ULS, we have all teamed up together for this wonderful session. As I said, Mr. Dave is such a magnetic personality that he attracts everybody. Karanjit, the fact that the Bar Council has also called upon Mr. Dave, and he's talking on a different topic and a different spectrum on that day. And today he's talking on a different spectrum. If we go to the YouTube and different channels, Mr. Dave, you will find Mr. Dave writing on different fields. That only shows the volume, the ease with which he speaks. Everybody cherishes every word he speaks, every word he writes. It is just like it's all gold, 24 karat gold when Mr. Dave speaks. Mr. Ratan Singh, who is the director of ULS, just I will call upon introduce the ULS to Mr. Dushyant Dave and the participants.
Yeah, thank you, Vikasji. Vikasji, really, this is a platform where the academicians, the students, and bench and bar can sit and can deliberate. So I'm very happy that you have involved University Institute of Legal Studies, which is a very, very prominent and a premier institute in Chandigarh. Because reason being, we have established in 2004, and just in 16 years, we have got the laurels, wherein we can say that our students and our teachers, they are earning the name and fame at national and international level. And involving ULS and our students and our alumni, because reason being, what I feel is that many of our students passed out are the colleagues there in their practice in Punjab and Haryana High Court as well as in the Supreme Court. They all are sitting before us, and certainly this platform will definitely enrich to our students, to the teachers, and such type of platform will definitely support us continuously, so that we can sit and we can listen to the legal luminaries like Mr. Dushyant Dave. Because reason being, I remember that I have just listened to him for just 2 minutes in the Supreme Court, and I just remember these 2 minutes of our arguments before the Supreme Court. It was really mind-blowing. So thank you very much, Mr. Vikasji. You have involved ULS along with us. Thank you.
Thank you, sir. It's a pleasure for us that being an alumni of Punjab University and Punjab University has associated with us. It gives us immense pleasure. Let's not take much time. Over to you, Mr. Dushyant Dave. Thank you, sir.
Good evening, everybody. We are meeting in extremely difficult circumstances. One of the biggest crises that humanity can ever face, at least in our lifetimes, we are facing today. And therefore, it's absolutely necessary that we as lawyers, the upholders of civil liberties, upholders of justice, really do continuous brainstorming during this crisis as to how we can help the administration of justice, we can help the cause of justice, how we can help the real stakeholders in our system, the litigants. And that is why I congratulate you for organizing these webinars and these seminars. It's a fantastic effort, and I think that you're really contributing a lot to the society by doing this. I thank you for inviting me. It's my privilege to be here with you, and I am really touched that you have decided to hear me out today. I thank the chairman of the Bar Council of Punjab for his very warm words. I don't know whether I really deserve them or not, but they were very flattering, and I thank him for that. We have today, decided to discuss a subject as to future of arbitration. See, it's a very difficult subject to debate. Let me first and foremost at the outset tell you that I'm extremely skeptical about arbitration in India. And I have lost my faith in arbitration long back. So it is with that footnote that I'm going to address you. And secondly, most important aspect is this, that COVID-19 is an extremely unfortunate situation for millions of Indians today. And let us hope and pray together that these Indians are taken care of by Almighty. They do not suffer, both in terms of their health and in terms of their financial well-being. And the Almighty, perhaps we pray, will look after all of us, all the Indians. But at the same time, it is very important to understand that COVID-19 provides a great opportunity, a great justification, a great reason for members of the bar to begin to debate the alternative dispute resolution mechanism. And this is something very, very important, because let me tell you very bluntly, the judicial system is virtually in a coma today. I have said so in writing in my articles for the last couple of weeks. And as a result, I think the justice delivery is virtually not taking place. This is not a happy situation, because ultimately, whatever may be the challenge, the doors of the courts cannot be shut out as they are shut out. Yes, some urgent matters are taken up, but we all know that the urgency is decided on purely discretionary basis, which is very unsatisfactory. And the litigants who are waiting in millions are really awaiting justice for themselves for a long time. We have almost 40 crore cases pending in courts, 4 crore cases pending across the country. And there are thousands of people who are in jails wanting to get out. Their bail applications, their appeals are not being heard. There are many people who are detained. Their habeas corpus petitions are not being heard. There are lots of other people who need immediate justice. They may be workers, they may be tenants, they may be business people, they may be farmers. Everybody needs justice. And it is therefore, to my mind, extremely unacceptable position that the most powerful of the three wings of the state, the executive, the legislature, and the judiciary is today virtually remaining silent and watching what is happening. So this provides us a great opportunity to discuss, because there is one more issue that we all have to really keep in mind, that even after COVID-19 is successfully harnessed and we are able to overcome, which most experts in the world say will take several months, if not couple of years, we must understand one thing, that we should be able to provide justice, as quickly as possible. Now, is our legal system ready for it in terms of technology? My answer is no. The experience that I have had in the Supreme Court, hearing cases through video conferencing, is, with greatest respects, extremely unsatisfactory. And this is hardly the way in which the judiciary of the world's largest democracy should be really conducting its affairs. Now, if this is the position in the Supreme Court, I cannot even imagine what must be the position in the courts, subordinate courts, and the lowest rung of the courts in the country, where litigant really needs, to get immediate and instant justice. So I think this is another aspect that we must really keep in mind, that digitization is not going to take place easily in our judicial system. The executive is not interested in, giving money to the judiciary in the kind of, amounts which will require a complete overhaul of the system, and therefore to move a very smooth and a quick transition from the present system, the paperwork, into, the digitization and ultimate, I think, hearings of the courts through video conferencing. So that's a long way across. Now, therefore, what is it that we should be doing? We have to really find a very robust alternative dispute resolution mechanism. And when I say alternative, I mean it must be alternative. Today, arbitration is not an alternative to the existing system of administration of justice. It is merely a one more layer for this country. Now, this is not how arbitration was conceived in the first instance. Arbitration was conceived to resolve disputes, differences, and conflicts between the parties, especially in commercial contracts, so that there would be finality and it would be achieved. That resolution of their disputes would be achieved at a substantially low cost and as speedily as possible. Because we all know that men of commerce and business cannot afford to wait long for resolution of their disputes. They have to come very quickly. Now, we have to therefore understand, first and foremost, that arbitration must become an alternative resolution dispute mechanism in this country. Unless that mindset comes, it is impossible for us, however good the law may be, however good the judicial system may be, the arbitration is not going to be successful. And let us understand one thing, and perhaps all of you appreciate it even more than I do, that India is one of the fastest growing economies of the world, at least it was before COVID-19 or before demonetization for that matter. And India actually needs industrial revolution, in the sense we need, really agriculture alone cannot be depended upon for keeping this country going. We have 130 crore people. We need therefore investments in every section of the society, in infrastructure, in manufacturing, in service sector, in exports, and in agriculture. All these investments can only be justified if you have the latest and best technologies. Now, India doesn't have those technologies. The world has them. India does not have the money for all these revolution that the world has that. We are talking about investments in trillions and trillions of dollars. So both the investments coming from abroad and the technology coming from abroad have to be protected. Unless they are protected, nobody is going to invest in India, at least in the sizable amounts. And unless they invest in sizable amounts as quickly as possible, India is going to face one of the greatest challenges. Unemployment, hunger, starvation, all are really not impossible to be faced by this country. So we have to understand why we need a very, very credible alternative dispute resolution mechanism. The foreigners who want to invest in India distrust our judicial system. And you all know why they distrust it. It is impossible for us, when I go abroad or when I am asked by foreign friends, lawyers, and many a times the clients, as to whether their investments and technologies are safe in India, I find it very difficult to tell them yes. You have to give an honest answer, and we can't give an honest answer. So this is something which is the basic foundation why we need this, arbitration to succeed in the right way. The other, COVID-19 also gives us another opportunity. China today is, if I may say so mildly, being virtually treated as pariah in the international community for whatever reasons. It is therefore right time for this country to step in and fill the void, the vacuum that is created or that is going to be created by China in terms of manufacturing, in terms of exports. All this can be easily achieved by India. Now, and foreigners would be more than happy to come and invest here because we are a democracy. There is a rule of law, although that rule of law is not robust, but at the same time, it is much better than China. So therefore, we really have tremendous opportunity. So we are the fastest growing economy. We have a large population. We have the largest population of young people who can be found to work in all these factories or infrastructure projects or service sectors or export companies or even agriculture. They are there in hundreds of millions. So all these are our strength. Now, those strengths must be converted into realities. Let us understand one thing, that we cannot run away from the fact that unless we provide this credible mechanism of arbitration, people from abroad are not going to have trust in this country to invest. Now, what do we do therefore? The responsibility lies to a great extent on every stakeholder in the world of arbitration. It lies on the lawyers because they must always advise the clients honestly. What do we do today? Whenever clients come to us for invoking arbitration, first we try and see that I would say soft or supportive person is appointed as the arbitrator. Now that's our first mistake. Secondly, whenever the awards come to us, even when we know that the awards really should not be challenged and there must be finality, we advise parties to challenge them, on a drop of a hat. So first and foremost, we have to make sure that we really, as lawyers, give honest advice. Where arbitration will succeed, because let us remember one thing, it is not that our business will increase as lawyers by more litigation in arbitration. Our business will increase by more arbitrations. And more arbitrations will come when people start trusting that yes, this is a credible mechanism, it brings results, and the parties are successful. See, in every litigation or every arbitration, only one party has to succeed. The other party has to fail. But it is our responsibility to tell the failing party that you have failed for rightful reasons. Now, for that, we have to create credible arbitration mechanism. Now, we can create that arbitration mechanism if we give right advice to constitute right arbitral panels. This is nothing new, but I have said maybe 100 or 500 times in the past that one of the single most reasons why arbitration in India is a failure is because of retired judges. And I actually feel that retired judges have virtually destroyed arbitration, or at least my faith in arbitration. And they have converted arbitration into nothing but another kind of litigation, or alternative, instead of alternative dispute resolution, an alternative judicial system. Now, this is not what was envisaged. This is not what we want. Now, this is where we have to really realize that we must start, having a great, introspection about it. We must understand that India generally has ad hoc arbitrations. Almost 90 to 95% of arbitrations are ad hoc. As a result, what happens? That we appoint these arbitrators in an ad hoc manner. Normally, we only turn to these retired judges more often than not, or maybe sometimes retired engineers if the disputes are relating to construction contracts. But this has to change. You have to have very credible arbitration institutions. Look at Singapore Arbitration Institution today. The Singapore Arbitration Institution has, in last 5-7 years, acquired a world famous image. It is trusted by one and sundry. And some of the Europe's best law firms have opened up their offices in Singapore as a result of that. What do we have? We have nothing. Now, institutions like LCIA, institutions like American Arbitration Association, or the International Chamber of Commerce in Paris, these are all extremely credible arbitration institutions. I'm not for a moment suggesting that they are flawless. Of course, every institution is bound to have flaws, unless, of course, they are headed by the right people, which Singapore is today. So we have to create this kind of institutions and ensure that both our domestic and our international arbitrations are conducted under the aegis of such credible institutions. So once you have institutions, you have rules, you have cost control, you have control over appointment, you have control over procedure of the arbitration, and you ultimately have control over the resultant award. So as a result of that, we might be able to get some outstanding results if we can do that. Unfortunately, nobody has been able to succeed. LCIA came to India at my request and suggestion. They opened up an institution here and they failed and had to wind up, to the extent that somebody filed a petition saying that how can they use the word London Court of International Arbitration. The word court can't be used. And the matter came right up to the Supreme Court on an issue like this, which was so irrelevant. It didn't mean a court. It's just a nomenclature which LCI has been having for almost 100 years. But this is how things are happening. So once you have this credible mechanism, now what is the other thing that has to happen? The other is that the parties also, especially the commercial people, must also now reconcile to the fact that they should only depend on honest and efficient arbitrations. The parties have to change their mindset also. Unless they change their mindset, nothing is going to happen. Because if a party which knows that I have an extremely weak case and I have terminated somebody's contract, completely illegally, and I don't want him to, get result immediately against me, I will necessarily advise my lawyer to appoint such an arbitrator who will drag the arbitration proceedings for a long time, or may even, deflect the very course of arbitration. Now, in that regard, the institutions like FICCI, CII, or Punjab Chamber of Commerce, etc., all will have to apply their mind together. They all will have to think. They all will have to seriously consider what do we want as a nation. General counsels of all these top companies. Today, almost every company has a law manager, or now they are called general counsels. All these general counsels occupy today very powerful positions in their organizations, and they are looked upon with respect by their managements. Their word counts. They must give honest advice to their management as to how the arbitration should be conducted. If it is, its whole purpose is to bring about a just resolution, then it should be done in a just way. Equally, the government has a great role to play. The government has to, it's not good enough to bring amendments after amendments that the Arbitration Act has been having. It's a 1986 Act, and it's been amended several times for no justification whatsoever. And even today, it's not, rock solid. It has many lacunas, and it is very difficult. And foremost, the government has failed to force institutional arbitration on Indians. Unless government forces the institutional arbitration, but coupled with that, government will have to ensure that credible institutions are created. There is an institution, for example, which was created under the aegis of government or out of government funds, and in Delhi. And I can definitely tell you that it's a very disappointing institution, although I have represented it at one point of time as a lawyer and defended it. So, but it was not worth it. That institution and spending of almost 100 crore of rupees by the government was really not, I would say, justified in the circumstances. So government is the other stakeholder which will have to. Now, lastly, who is the other stakeholder which is really important? Most important is the judiciary. The judiciary must be supportive of arbitration. Now, unless and until judiciary realizes that parties have, genuinely got freedom of contract, that freedom of contract must be respected by judges. That parties have entered into an agreement, and that agreement provides for certain, arbitration. Now parties have decided to go for arbitration. The judges must stay their hands off. What happens today? Right from the word, when the appointment of an arbitrator has to take place, the judges start, dissecting the arbitration agreement or the underlying contract itself to find out whether arbitrator should be appointed or not, and find million reasons why in given cases he should not be appointed. Now this was never envisaged. It's parties' choice, and if parties have failed to arrive at an agreement to appoint a person, the judges must step in and appoint the person and leave that person to decide the disputes between the parties. Then again, during the process, interim measures of protection, to a great extent, they are absolutely necessary, because unless there are interim measures by which the assets or the subject matter of the arbitration is preserved, there is no point getting a worthless award in the end after 6 months, 1 year, or 2 years. So judges, to that extent, under Section 9, must use their powers to ensure that subject matter of arbitration is preserved as best as possible. Then the real problem is examining the challenge to the award. Now, when the award is challenged, just look at it, that by one judgment in saw pipes, by merely writing patent illegality, every award passed after that judgment came to be challenged in every court across country. So as a result, what happened? That thousands of those awards are stuck up in district court or subordinate court or high court or even Supreme Court without being decided finally. Of course, now the judgment has been clarified, it's been watered down or almost ruled out. But what I'm trying to impress upon you, friends, is this, that judiciary can really be obstructionist instead of facilitator. In Singapore, for example, The reason why institution is succeeding is because the judiciary is extremely supportive to the institution. The awards are examined with a very, in an extremely narrow and manner which is specifically provided under the New York Convention. They are not being examined in, for example, our Supreme Court in one case, I think, I don't know, it was Justice Thakur perhaps, he virtually brought principles of judicial review of administrative action into examining a challenge to an award. Now this is unheard of. This is unheard of. So this is where the judiciary comes in, that the award must be tested. Of course it must be tested, because the losing party cannot just, unless they accept it voluntarily, they must have a right to. But that right is extremely circumscribed and limited by Section 34 or under New York or Geneva Convention in Part 3. Now it is only on those grounds that you can examine the award, and judges must strictly confine. Secondly, the judiciary has a duty to create an absolutely independent wing on commercial side. They may not call it commercial courts, but judges who are constantly and virtually permanently during their judicial career hearing only cases relating to arbitration. If this happens, the approach of the court concerned will be extremely balanced, it will be consistent, and it will be extremely sound, because it is based on well accepted principles of arbitration law. Now if you are going to change judges every month or every 15 days or even after every 2 months, then the new judge is virtually not going to grasp it, and before he grasps the subject and the law, he will be transferred out. So this is where judiciary will have to create kind of a wing of, or it happens in England, for example, on the commercial side in Chancery Division or even in High Court, judges consistently hear particular cases of which they are experts. They are not given any other subject, and this has happened to judges for 10-15 years at a go. So they only hear those cases for 5, 10, 15 years, and the result is the law which has been produced, churned out by these judges, is absolutely outstanding. That's what we need. Equally, the judges will have to be very quick about examining the challenges against the award. If you are going to take 2, 3, 4, 5 years in courts to examine a challenge, and then it comes to the appellate court and the Supreme Court, then I think the whole purpose of arbitration is lost. We cannot really afford to do that. So this is something which we really need to change today in this country. Unless we change the mindset, the attitude, the approach, and of course, the honesty of purpose. What is really missing is the honesty of purpose today. Because, if you are honest about this being the truly an alternative dispute resolution mechanism, then we can achieve a lot. Nobody can stop us. And this is where we really need to now focus as lawyers. We have a great responsibility. Let's not forget one thing, that a lot depends on our shoulders to ensure that democracy succeeds, rule of law succeeds, administration of justice succeeds, and the citizens get what really they deserve, the real justice. Unless we as lawyers collectively stand up, start thinking, start debating, and start taking action, it is not going to be feasible, it's not going to be possible. Believe you me, I've been a lawyer for 42 years. I respect judiciary, I respect judges, but I can tell you one thing, judges, retired judges as arbitrators are nothing but disaster. And we must therefore, stop appointing them. Look at the legal profession. In every part of India, it's not just in Punjab, in Delhi, in Bombay, in Chennai, there are outstanding lawyers who are of world-class caliber. They can be appointed as arbitrators. There are other experts, top-class architects, engineers, genuinely top-class, independent, competent, honest. These are the kind of people even from industry. So we have to really realize what we want to do. We can't just, go on appointing retired judges in every arbitration virtually, if not, every second arbitration, if not all. And ultimately, what do we get? So we have to now, and secondly, as lawyers, if we want to succeed in arbitration, we should become lawyers of and for the arbitration. If we don't, then I think we are going to fail. If we are going to be dabbling in legal courts and in arbitration, arbitration is a part-time, profession in this country, both for arbitrators and lawyers appearing there. That has to stop. It must be full-time arbitrations. And if it is full-time arbitration, I can tell you, it's not difficult to resolve disputes. I have seen personally, I'll give you a very interesting example, of an international arbitration where sometimes a lot of time is consumed. Even those arbitrations take 1 or 2 years. But there was a very extremely heavy arbitration where the claimant was represented by one of India's topmost lawyers, and I was appearing for the defendant. Claimant was Indian. The defendant was an Italian company. We were in Singapore, and the arbitral tribunal consisted of 2 outstanding arbitrators from the international community and a former Supreme Court judge of India. And I discussed with my colleague on the other side, a very respected lawyer, Mr. Salve, that why can't we dispose of this matter as quickly as possible, because the tribunal is asking for dates, and you are finding difficulty in dates, and I am finding difficulty, and the tribunal is finding more difficulty. So he said, what can we do? We have a lot of witnesses to examine, and how can we do it? I said, we can. So we agreed that we will finish examination and cross-examination of witnesses in 3 days. On the 4th day, we will start submissions and replies, and on the 5th day, rejoinder, and finish with it. In 5 days flat, in 1 week, we finished one of the heaviest arbitrations where the claim was almost more than $250 million. And the result was outstanding. Now, what I'm trying to say is that it is not that we can't do it. We can do it if we have really a mindset. If we want to really be honest to ourselves and honest to our clients. And this is what really is need of the hour. Unless we change this kind of a mindset, it's going to be very difficult. Please do not expect the government to act. Do not expect the judiciary to act. We have to act ourselves. And this is the right time for us to start the beginning. This particular webinar today, let us treat this as the beginning of a new era in arbitration. Let us try and work out. Let us put in. We have, some really outstanding thinkers in the field of arbitration. People like Mr. Arvind Datar, people like Mr. Darayas Khambata in Bombay, people like even Mr. Salve. All these people, we can really, put their heads together and try and achieve outstanding result. Unless we do that, we are bound to fail. The judicial system is crippling, and I think if we don't substitute it with a genuine alternative dispute resolution mechanism, believe you me, the legal profession will suffer. Thank you very, very much.
Thank you. As usual, your stand towards any issue is bold and clear. We don't have generally all the topics, or whenever the speaker comes, he takes a neutral side to the effect. But your ideas are quite bold, which normally nobody speaks on the platform. So we have the questions posted in the chat box, and everybody wants to have your perspective on that. So,
yeah, sure. Please go ahead.
I will just tell the participants, Mr. Dave we will only post the questions in respect of arbitration. Please don't post questions which are not relevant with the topic, then the entire theme of the topic goes away. So in several ad hoc, Prerna Salgi asks, in several ad hoc arbitration, the arbitrators are inexperienced in case of management and lack of requisite knowledge of law and procedure relating to arbitration. According to you, what measures can be taken for training them, if at all it is required?
See, that's a very valid question. We definitely need, what is really happening in this country is that as lawyers, once we start practicing, there is nothing called continuing legal education program. And fortunately, our Advocates Act is so very beautifully drafted that we think that we are master of all, and we therefore can dabble into everything that comes across. Now, to some extent, it is okay, but it's not really. Ultimately, we must realize that unless and until excellence is achieved, nothing is going to, the resultant product can never be satisfactory. So I agree with you that yes, more often than not, the arbitrators do not know the procedures. They do not know how to set the procedures. Many a times they do not know the law. And that is where I said that institutions will provide an umbrella where the procedure is extremely well defined. If you look to all these rules of LCIA, AAA, or a Singapore institution, even Chinese arbitration, CTAC, their rules, every one of them have fantastic rules, extremely well thought of, very well laid out, constantly reviewed and revised to suit the needs. And those institutions provide constantly programs for training the arbitrators. Now, that's something, for example, Chartered Institute in London, they provide outstanding training to arbitrators. Things like that have to be done in India. Unless we do these two things, institution together with continuous training through a credible institution, and including perhaps universities may start actual courses, not of teaching just arbitration law, but arbitration procedures. So that can perhaps help.
Vishal asks, how would a non-legal person ensure the legal procedures are followed? Else the award would be repeatedly fall on technical grounds. This isn't in view of the take given by you that we should appoint the persons beyond law. His take is that at least the judges know the technicality, etc., how to wriggle out the procedure.
No, I don't think that's true. I'll tell you, because arbitration is not about technicalities. We are the ones who are trying to throw out the awards on technicalities. The awards are not to be thrown out on technicalities. They can only be thrown out on specific grounds which are mentioned in Section 34 of the Act, and which is based on the New York Convention, UNCITRAL Convention. So it's not. I have seen world over, for example, some of the best arbitrators. I remember in one arbitration that I was arguing, a chartered engineer was there, and he was presiding, and sitting next to him was Lord Mustill and another QC from England. And believe you me, this chartered engineer gentleman was, nowhere less compared to a man as great as Lord Mustill was, or to the other Queen's Counsel who was sitting on the panel. So this is a misnomer. See, ultimately today the business is becoming extremely complex. Take for example energy, or construction, or any other area where technology, for example. Look at technology today. All these areas where you need experts, to advise. Their presence of one of those on the arbitral panel will be of immense value to the other two learned, legally trained minds, because then he can clarify many of the doubts, provided, of course, this process is an honest process. So I would beg to disagree with you. I would say that please rethink about it and consider it in the context of the complexities of business that we are facing, because arbitration is not just about law. It is about business. It is about men of commerce and the business that they carry out, and business today is becoming far more complex than lawyers can really understand.
Thank you. So, Parth Contractor asks, is it not a time to do away with the ad hoc arbitrations by law and only permit institutionalized arbitration, whether domestic or international?
I have believed for a long time that institutional arbitration should be made compulsory in this country. And it is my regret that despite my repeated requests to many people, including some of the most powerful friends in government, including late Mr. Arun Jaitley, whom I hold extremely highly, a personal friend, a colleague, and one of the finest minds in the country. But even him, I could not persuade to go for compulsory institutional arbitration. I don't know why it has not come up. Even the smallest countries, I mean, countries like Malaysia, Sri Lanka, all these countries, Indonesia, they all have excellent arbitrations. Forget Europe. Europe and all are much more developed. But even in Southeast Asia, most of these countries have really very good institutional arbitrations. So I would definitely say that government should step in. Unfortunately, I don't know why government has never thought about it, because it's harming government's interest. Let us understand one thing. In the absence of these credible arbitrations, most arbitrations that government is fighting today, running into billions and billions of dollars, they are losing out. And government is also making the same mistake that the litigants are making, ordinary litigants, by appointing retired judges who have no idea, and they can't stand up in front of the other two international arbitrators sitting in London, Paris or Singapore. So government is suffering. I mean, it's losing some of the biggest arbitrations today. So there is no realization, unfortunately. Nobody wants to understand. Nobody wants to apply its mind. And nobody wants to debate. That's the saddest part.
Sir Anurith Budwal, what should be the criteria to appoint an arbitrator, according to you?
Well, it's impossible to give a precise definition of an arbitrator. But normally, I mean, for example, worldwide, who are the arbitrators? They are generally from the pool of lawyers who exclusively practice in the field of arbitration. So generally, these people, their life is only arbitration. They rarely go to court. And they know every in and out of the arbitration. So first and foremost, we must therefore create a pool of lawyers in the country, and we have some of the finest talent in the country who are exclusively devoted to arbitration. So, and as somebody earlier rightly asked, that we need a legally trained mind. So these lawyers pool is legally trained in terms of law, in terms of procedure. Along with that, of course, experts from various fields should also be picked up by the arbitral institution on their panel. So depending on a particular dispute, that particular expert can be brought in. Now, for example, there is a dispute about a telecom company like Airtel or Vodafone or somebody or Jio. Now, and the dispute is very, running into huge figures. So a person who on a panel of 3 is one of the technology experts in the field of, telecom, he can be of immense help to the tribunal in arriving at the right conclusion, because the contracts today which are drawn up by the parties are so complex and so lengthy that it is virtually impossible for ordinary lawyers to understand them in right perspective. So this kind of, ultimately this kind of a pool will have to be created by institutions, and it's not an easy process. It can't be done overnight. It's a long process, but we'll have to start training people right from now. We have to pick up and start training them, and then only we can succeed.
So the point is well taken. Once you are the president of the Supreme Court Bar Association and you have been going to the various virtual platforms, we can all work out on the modalities how the training can be done. It can also be done under the aegis of the Supreme Court Bar Association. You being there at the helm of the affairs, I think everybody will latch upon that. We can have some workshops on that, at least some nitty-gritties one can learn about that. What is your take on that?
Well, bar associations can certainly provide, I would say, some comfort, but it all depends on the response of the highly qualified and experienced top lawyers. They will have to really devote time to the bar, especially to the young members of the bar, and impart training to them. Their experience must tell them what exactly is the future for these young lawyers. Unless they are willing to sacrifice, it's very difficult. And I can definitely share with you as president of the bar that it's not easy to persuade these top lawyers to find time for these kind of training programs. So, but it's not impossible. I'll tell you, when I was president in 2016-17, I requested one of the greatest, legal, professors of the country, and a man who really has given us a fantastic new legal education, Professor Madhav Menon, first director of the Bangalore Law Institute. I requested him, and he was well past I think he was in his late 70s or early 80s. But when I talked to him about it, he grabbed it with so much of enthusiasm that within 24 hours, he sent me a full program for 3 days of training. And it included varied subjects. And then he told me that these are the speakers he would like to invite. Fortunately, I spoke to some of the best lawyers in the country. He spoke to some of the best legal, teachers, professors in the country. And we put up a fantastic faculty where people like Mr. Fali Nariman, Mr. Soli Sorabji, late Mr. Andhya Rujna, late Mr. Ashok Desai, and amongst others, they all came and spoke. And, it was so successful. We selected only 75 lawyers. We did not want to go beyond that. But for 3 days, these 75 lawyers, listened with rapt attention. And it was amazing. It was like a school. We also, I as president and my vice president, Mr. Shekhar, we both attended as in IT just to see. And it was absolutely marvelous. So it is possible. But I must say we have lost Professor Madhav Menon, and it will depend on, other people, your director of the Law Institute in Punjab who's on our guest today, who's co-sponsoring this program. People like him, people like Dr. Rajkumar of the General Global Laws Faculty, and many others who are, outstanding academicians. They will have to really contribute.
So once you yourself say that the attempt made by you is successful, they say that if you falter on the first time and then you don't rise up, that is a mistake. Or if you don't try, that is this thing. But once we have had a success, what you say, though we haven't experienced it, we take every word of yours. I say that we started this platform. It's my personal experience. When the first experience we started with the first webinar, we just had 12 persons participating in that. Gradually, like Professor Ratan Singh has tied up with us, you have come on the platform. Let's try at least on the virtual platform. It's an open issue where people would love to join it. You give us the team, you tie up with them. It's my endeavor that we will bring it on the Beyond Law CLC. The Punjab University is agreed. I will talk to Dr. Rajkumar. Let's take the things forward. Today, after this show, I will contact you. You just give us. It can be with the Supreme Court Bar Association, whatever way is there. And I have seen the webinars, at least during the lockdown periods, are actually enhancing the knowledge. People are feeling, rather than watching TV shows, continuously talking with the families or continuously going on Zoom and talking with friends.
I completely agree with you. We have to make. But, I must warn you one thing, that initial enthusiasm remains. What we need is a sustained effort across the country. Unless we have that sustained effort across the country, and for that, institutions like Bar Council of India have to play a major role. Unfortunately, I see very little, help coming from institutions like Bar Council of India. And I don't think they are really genuinely interested in achieving excellence in legal profession. So I don't mean any disrespect to anyone, but these are extremely serious thoughts. These are extremely serious issues. And unless people are willing to really take very huge strides, it's not going to work. So, but of course, I speaking for myself, I'm always there to help, friends in the bar, whether I'm president or not. It's always a joy and an honor to work for the young generation of lawyers.
So I am only saying, at least in our platform, like the Karanjit Singh had come, Suvir Sidhu, the secretary, the all other bar council, at least in Punjab and Haryana, are quite easy to latch up. They will take up the issue. I am saying it's better to try and fail rather than failing without trying.
No, I agree. Let's not debate on that. I'm in complete agreement with you.
Yes, sir. We will do that. So, Rohit Verma asked, don't you think lawyers play a big role in delaying the justice system? What is your take on that?
Lawyers can play a big role. He's asking for whether lawyers can play or whether lawyers can play a role in
What is your take?
They do. Yeah.
What is your take? Whether they do it or not?
Yeah, of course they do. There is no doubt about it. The success or failure of legal system depends a lot on the lawyers. And let us understand one thing. If the bar is strong, if the bar is, in the right direction and thinks, positively, it can achieve a lot. If the bar is weak, if the bar is not willing to stand up, then we become captives of the judiciary, the judges. And that's what is happening today across the country. We as, defenders of constitution, we really have a great role on our shoulders. And we have to work hard. We really need courage of conviction. And we must be willing to stand up and speak our mind and guide the judges. Because if collectively we can do it, I dare say that no judge would ever dare do something which is against the interest of rule of law. But that's not what is happening. We are a divided house, and it's not very easy for us to achieve the results which which need to be urgently addressed.
So, Shivam, what is the difference between award, conclusion, and decision in arbitral award?
Well, there is not much difference between ultimately what is an award. Award is a very reasoned, report of at the end of the arbitration process, and ultimately the award has to decide its conclusions and what is to be awarded to the parties. So the last part is the award, which is called the award. What is being awarded? It's like judgment and a decree. So the award actually constitutes what really party a litigant is entitled to or is not entitled. Rest is reasoning and consideration of the material or evidence on record.
Taruna Jakhat, how far Indian Council of Arbitration an effective institution in enabling arbitration a successful mechanism for dispute redressal, as it provides its own rules?
Indian Council of Arbitration.
Yes, sir.
With great respect to late Mr. H.R. Bhardwaj, I must say it's an extremely disappointing institution. Manoj
Kumar, latest amendment to the Arbitration and Conciliation Act has given similar powers to the arbitral tribunal to give interim remedies or on par with the court. Is it not going to be disastrous?
Oh, you see, once the arbitral tribunal is constituted, then the arbitral tribunal has been given powers to grant interim measures of protection, provided those measures are really enforceable. If you need help of a municipal court for measures which can be only enforced through the power of a court, then you still have opportunity to go to court under Section 9. That's not taken away. So it's trying to balance, because what happens is today everything is being taken to the courts in the garb of Section 9. And that litigation also goes on for a long time, and as a result the arbitration process gets stalled. Abroad, for example, in most arbitrations the parties rarely go to court, because you see, once an arbitral tribunal passes an order, the parties abroad respect it and honor it. In India, unfortunately, the parties play little this thing with the tribunals and do not always honor their interim orders. So to ensure that they are honored and implemented, parties have to rush to the court. So this balancing is not bad. I feel that it can achieve its purpose, and there is nothing wrong about it. It's on international pattern.
Aparna Goswami apparently seems to be a student. She pitches in, what advice do you give for the students who want to take up arbitration as a career?
Well, concentrate on commercial laws and of course arbitration law as much as you can, and then follow it up in your career as lawyers strictly with arbitration law and arbitration practice. That will ultimately take you somewhere. So that's the only way one can do it. And the students have now today various opportunities. It's not just as lawyers that they can do very well in on the bench as young judges. They can do extremely well now in most companies, because a lot of companies hire these young lawyers with 5 years practice or 10 years practice as in-house counsels. And these young lawyers can acquire tremendous experience while working in those companies on commercial laws and arbitration law, which they can then subsequently capitalize by establishing themselves in the field of arbitration.
So Neha Sangwan pushes in. The Supreme Court in 2018 barred the entry of foreign lawyers in India, including in international commercial arbitration. Could you share your opinion? What is upon that?
I think it's absolutely wrong for us to bar foreign lawyers coming into India to practice on international commercial arbitration. Every jurisdiction in the world allows it. I have myself been on the board of the American Arbitration Association for 7 years. I was on the board of the London Court of International Arbitration. I have been on the board of the International Council of Commercial Arbitration. I tell you, I mean, these are matters of mutual respect. You can't just take a view, and try and live in some kind of a well where, you know the story of that, you can't just grow, you just can't grow unless and until you allow. What is the advantage? See, why do foreign lawyers come here? They come for their clients. They don't come for Indian clients. Now, if he is coming for his client from America or Italy or Switzerland or France or China or wherever to India, how does it matter to you? You should allow, because his client has more faith in his lawyer there. Like we will have. When Indian companies will arbitrate in America or Europe or China, they will take their own lawyers. That's natural. So I don't think this kind of an approach is a very... We need to be broad-minded. We don't need to. If we shut us out like this, then I think the world will shut us out too. And that's not good for us.
According to you, it's an eye for an eye and a tooth for tooth will ultimately do. If we debar them, they will debar us.
Yeah, it's not. We don't grow then. Today, I mean, for example, the international arbitrating community is so highly, focused, so highly experienced, so well trained, that if they can come and give us, lectures in seminars, they can come and give us, lectures in our universities. And I can tell you, large number of them would come free of charge. Some of the world's best minds, if the universities and top, institutions were to allow, invite them, or lawyers' body. And we have to gain a lot from them. We also will contribute to them. So I don't think this kind of a shallow approach will help us in the long run.
Aishwarya Iyer says, what are the unshakable prerequisites that a client should have to ensure that he/she gets a fair shot at a favorable reward?
There's nothing, you can't just generalize that, nor can you really pinpoint. But if you have a good lawyer, sound advice and honest advice, and if you have appointed a right arbitrator, fiercely independent arbitrator who's well respected, then I don't think, and if you have a case, then I don't think client will lose. See, when we go to court, for example, today, when we know we have a sure case, we generally end up winning. When we know that we have a bad case, we know we are going to lose, and we lose. Unless, of course, sometimes judges spring surprises on us, and which happens more often than not these days. But otherwise, we know what the strength of our cases is. So that's why I'm stressing a lot that it is very important for us to have credible arbitral process. And that process must begin with lawyers. It must continue with the arbitral tribunals, and it must continue with the judiciary, which is going to supervise the arbitral process.
Charul Mathur poses a question. Arbitrations are generally headed by the judges, and are being on arbitral panel, judges tend to have the same mindset which they have for litigation, which according to her diminishes the very purpose of the arbitration. What is your take on it?
I have said in my speech, if you heard me, that I have a complete distrust of retired judges, with greatest respect to them as arbitrators. and they can really conduct themselves extremely disappointingly. I will give you one or two examples. For example, there was an arbitration which was in Udaipur. This was between the Oberoi Hotels and the Maharaja of Udaipur. And the three learned judges were all retired Supreme Court judges, headed by a former Chief Justice of India. And in one of the hearings, the seat was in Udaipur, so we had to go to Udaipur. In one of the hearings, both me and my counterpart on the other side and our instructing law firms all agreed that the hearing has to be postponed. I spoke to the presiding arbitrator, the former Chief Justice. He readily agreed. I spoke to the arbitrator appointed by our clients. He readily agreed. But the other learned arbitrator said, no, we will go to Udaipur and then I'll attend the hearing, which means I'll charge the fees and then do it. In the same arbitration, they conjured up these learned arbitrators that the claim and the counterclaim will be treated as separate for the purpose of charging of fees. Now, it's impossible to control these arbitrators. And if you offend them during the course of arbitration, you might end up getting an adverse order only because of that. So it's really it's a catch-22 situation. We really need to do something. There are, of course, exceptional former judges who are very, very good. People like Justice Sri Krishna and many others, they are there. But by and large, they bring the all the I would say shortcomings of litigation into arbitration, which instead of becoming a speedy process becomes extremely lengthy, which instead of becoming cost-effective process becomes extremely expensive, and the result is not efficient and a merit-based arbitration process or even the result. So I think that, and I have seen this virtually across the country, this problem.
Radhika Verma, in case of international investment arbitration, the initial remedy is to approach domestic courts. Once all domestic remedies are exhausted, only then can arbitration be instituted. How far this remedy to approach the domestic courts is justified?
Sorry, repeat the question.
So, in case of international investment, arbitration is the initial remedy is to approach the domestic courts. Once all domestic remedies are exhausted, only then can arbitration be instituted. How far this remedy to approach domestic courts is justified as per you?
No, even in treaty arbitrations, if the arbitration clause is there, you need not go exhaust the district court. Is she asking in respect of the award, or is she asking in respect of the dispute?
So, rightly or wrongly, we don't allow the unmuting in rarest of rare cases, because already the questions are pouring in.
See, I'll tell you one thing, that investment treaty arbitration is an extremely complex subject. India has ended up signing bilateral treaties with many countries in respect of investments which are already causing immense damage to India as a nation. In fact, there is this decision by an international tribunal in White Consolidated, I think of Australia, where the award has completely misinterpreted, turned it upside down the treaty, and given an award which unfortunately government of India accepted for unknown reasons, and that has become some kind of a law in treaty arbitrations. Secondly, we have refused to sign as a nation the exit investment treaty. As a result of that, the arbitrations are also now being conducted under the bilateral treaties and not under a multilateral treaty. So these investment treaties are extremely complex, and they need an entirely different, different group of arbitrators and lawyers to understand them and handle them.
Sir, Ritesh Khatri, after the Perkins judgment and more particularly taking into account the intervention of courts in hand, as on date, would it not be interfering into the objects and purposes of the Act of 1996? Section 14 is killing nowadays, as the courts have started interpreting de facto and de jure in length as much as possible to them to go deep into it.
Well, as I said, that courts have no business to go into these aspects at all. And it was never intended that Section 14th Amendment would bring about the approach that the judiciary is adopting now. So I don't think so. See, one thing, I'll tell you in one word alone, that judges must accept a hands-off attitude towards arbitration. Unless they do that, it's only in exceptional cases that they can interfere. And certainly never, interdict arbitrations. The purpose is not to interdict arbitrations by, fishing out some justification from here and there.
So, Manas Shukla, how can arbitrations proceed in post-COVID scenario?
How what? Can you repeat,
what is the
please?
scope of arbitration post-COVID-19?
As I began by saying that it is a great opportunity. COVID-19, unfortunately, it's a great opportunity for the country to really, I think, generate a completely new, I would say, struggle or a movement for the purpose of making arbitration succeed. Not only arbitration, the alternative dispute resolution, other sources like mediation. It's extremely important. There is no reason why we should lock up people in litigation for 20, 30 long years. I mean, how can this country have 4 crore cases pending in courts? There are many cases which are pending in Supreme Court for almost 15 years. We cannot have a judicial system which is unable to cater justice speedily. Justice delayed is justice denied is a very well accepted norm. So you can't just do this. So this is an opportunity. If the government seizes it, if the industry seizes it, if the legal fraternity seizes it, something will happen. Let us hope that they all wake up.
But at the same time, as you said, that justice delayed is justice denied. But sometimes once the arbitrator is biased and there is no interference in Section 34, etc., then the other take, what we talk in law is justice hurried is justice buried. What is your take on that? Let's assume the arbitrator is biased and we say that there should be minimal interference in that. Then where does that maximum of justice hurried is justice buried goes?
That is why I said institutional arbitration is important, and institutions are extremely careful about having arbitrators. They won't appoint an arbitrator who has acquired an image of being biased. Maybe in one case he might do it, but next time the institutions will look at him extremely with great suspicion and circumspection.
So, Priyanshu Kamra, a young budding lawyer from the High Court of Punjab and Haryana, he asked, "Sir, how can the lawyers take up the matter to get the amendments in the arbitration reforms as you are suggesting it? How can we take it forward?"
Well, lawyers won't be able to do it individually, but collectively lawyers can certainly demand, if there is a all India movement and some kind of a, common thinking is applied, and ultimately some kind of a consensus is arrived at across the country, and a consensus document is produced by their lawyers. Don't forget one thing, that lawyers can exert tremendous pressure on the powers be. And this is, you must realize that throughout the freedom struggle, the most important role was played by the lawyers. Why is it? Because they all had moral conviction. And with that moral conviction, they carried the struggle ahead. We need moral conviction. We need struggle. And unless we can have a struggle, we are not going to do anything. So lawyers collectively can achieve a lot. I have no doubt in my mind that we will be able to ultimately do it. We have to have an all India, movement. And that movement should start sooner than later.
Shanil, judiciary is constantly interpreting the meaning of public policy so as to interfere with the foreign awards. What is your take? Rather, I take a step further. Why foreign award? It goes in all awards. The public policy.
Public policy is a extremely vexatious subject, and many judges, including English judges, have criticized this concept from time to time. But in India, public policy has been well defined by judgments of the Supreme Court in 50s and 60s. And the section itself is very clear as to what really is the public policy which should come into play. And recent decisions by the Supreme Court, especially Justice Nariman speaking for the court, has very beautifully, defined a public policy. So I think that concept has been sufficiently narrowed down now by Justice Nariman's recent judgment. I think that should hold good now for time being.
Mohit Advani. Sir, despite the legislature's constant attempt, latest with the 2015 attempt, to narrow down or limit the scope of appeal against an award, and to narrow down / limit the scope of interference of the courts in an enforcement of foreign awards, do you think that we still have not been successful in one manner or the another?
Very interesting. I'll tell you. There's I think Justice Chandrachud, Chief Justice Chandrachud, Senior Chandrachud once said that the Supreme Court is not final because we are supreme, but because we are last. If there was a court above us, everybody will challenge our judgments in that court. So I think in India, litigants don't want to accept the finality. We are a highly litigious society. So we have to really at some point of time understand that the whole purpose, when there are disputes, is to bring about an amicable resolution. Once you have put a faith in an arbitral tribunal, a good arbitral tribunal, once a robust process has been followed, then I think parties should accept and the lawyers should advise their clients to accept that award. So that, it's not challenged on a drop of a hat on every conceivable ground under the sky. So it all depends on people's attitude. Unless our mindset changes, I think, which will require a lot of time, I would say, that change of mindset. So we have to become much more conscious. The parties have to realize that you don't, gain anything by litigating. You are spending unnecessary energy into it, unnecessary money into that litigation. You can stop that and arrive at an amicable resolution and move on and do some next business. You can devote more time, but who will advise them? So that has to come from within them, and it has to come from the people who are advising them, the lawyers. So it's a very difficult process. Over the years, we have become extremely litigious. We just love to fight.
Tanish Aryan, how?
And just a sec. And two factors which really have encouraged us to continue these fights are, one, that we do not impose substantial costs on people. Abroad, why do people are afraid to litigate unnecessarily? Because the costs are extremely exemplary. Secondly, in this country, we do not stop people from lying in courts. Now, if you take action against people who file false affidavits, perjury is never ever really resorted to. We all come across every day affidavits after affidavits, plaints after plaints, writs after writs, counter affidavits in which completely false statements are made. We point it out to the judges and judges just wish it away. You send 100 litigants, in perjury for false statements before court, and you will see that the litigation comes to a grinding halt. So these are things which we have to think of. Unfortunately, we are not willing to do it.
So, Tanish Aryan, how to make arbitration process strong in India, unlike many other developed countries?
Unlike or like many other developed countries?
It should have been like.
We can, as I said, everybody has to change now. You must have heard me in my opening remarks. I have given all the reasons why we can do it, and those reasons equally apply to your answer.
Saurabh Kapoor asks, do you feel institutionalized arbitration will increase biasness towards the appointing authority? Because in many cases, one party is usually government.
Sorry, please repeat it.
So he says, what is your take once there is an institutional arbitration? Then the person appointed I can repeat the question. don't you feel institutionalized arbitration will increase biasness towards the appointing authority? Because in many cases, one party is usually government.
No, these institutions are fiercely independent. They are not under control of government at all. The LCIA, ICC, CTAC, Singapore institution, American arbitration institution, world over, they don't care a damn about their governments. They function fiercely independently, and that's what we need. We will have people who are manning these institutions who are so independent. The government merely becomes one litigant. That's it, nothing more. So I don't think government, but yes, it's not easy to achieve that. You are right. In this country, government has a great say in many things, and they have been interfering with many process in adjudication of disputes between parties. But I think in a short run, it can be changed with strong will and some decisiveness.
We are taking the last question, then we will have 5 minutes wrap up. Apurv, the government, while offering tenders, makes their own contract and appoints their own arbitrators, keeping their interests above everyone. What is your opinion? I suppose that stands answered by Parkinson's.
Yeah, but also parties should refuse to sign those agreements. If parties are willingly signing those agreements, then they should not turn around. Of course, judges are now realizing that those arbitration clauses are foisted upon the parties, and the judges are therefore now changing their attitude and many a times removing those nominated arbitrators from the arbitration process. So I think to somewhat extent judges have realized, and judges are correcting this. But the parties have a great responsibility. They should also resist thirsting of those clauses upon themselves.
So few questions have come, but we are not taking because we don't go beyond the time. But before we part, we will just have a 5 minutes wrap because you are a successful lawyer, as a lawyer, president of the bar. How do you feel that the lawyers as such, maybe in the corporate sector, maybe doing private practice, can make a mark? How should they prepare their case? How should they make a mark like you have made coming from your state and making a pan-India presence and abroad also? What is your take? What is the key to that success?
Well, it's one thing is definite, that hard work, and hard work alone pays. And secondly, you must be extremely honest. You must be honest to your purpose, to yourself, to the client, to fellow colleagues at the bar. And you should also have courage of conviction to speak up your mind. So if you combine all these factors, see, law today is not just about law. I mean, many of us have benefited because we have, a lot of other interests, including reading anything and everything that you come across. You read as many newspapers as you can. You read, commercial newspapers. You read some of the best magazines that country and foreign countries produce. You also get to know a lot from other books and novels that you read. So reading is something which every lawyer must cultivate, so that he has that art of, he has the acquisition of knowledge constantly in many ways. And you also then acquire art of speed reading, because when you get, briefs, or when you get documents from clients, you must have capacity to read them in the right way. And this is what is very important. I think so. It's the hard work. When a client comes to you, for example, first time, and comes with a problem, do not just believe the client. Tear the client apart. Take out every conceivable, document or correspondence which may be relevant to that dispute, whether he brings it or not. You ask him, you go on asking him, and tell him to produce everything before you. Once you have got all the documents, and if you read through all of them, then you will be able to systematically realize, like a story in a novel, as to what the case is about. It is that case, then you can really rightly advise the client whether he should follow up with that case or he should compromise. Now, therefore, it's very important for us as lawyers to succeed, to really be extremely honest with ourselves. And hard work definitely pays in the long run, whether you are, in a law firm, whether you are in courts, everywhere, hard work pays off. And of course, in courts, it's very important that while you may you may be able to stand up to your courage of conviction, but never forget your respect for judges and never forget your civility to the fellow colleagues at the bar. So those are things which one has to really, I think, follow unscrupulously and faithfully all through your career. I mean, it should never happen. I mean, even today when I cross walking in my corridor and I come across any lawyer who's senior to me in my age, I never forget to wish him. And this is something which young bar has to really understand, that law is a gentleman's profession and you have to learn to be gentlemen. So these young men and women who are outstanding, they have so much of opportunities. We never had those opportunities. We came across, the kind of cases that we handled in first 5 years were not the kind of complex cases that they come across in 5 days of their joining a law firm or a senior's chamber. They are today confronted with most, complex and most interesting cases so quickly in their careers. They should capitalize. They should, they should really make points of this experience on day-to-day basis in their, personal books and notebooks. And they then, if they go on examining all this, they really, it helps ultimately in the long run. So hard work, and of course, honesty.
So according to you, two H's are important: hard work and honesty.
Yes, absolutely.
Sir, you said that one should read fast. For that, what type of practice the lawyer would have to do?
So I think just you read as much. If you start reading novels, you will realize speed reading helps you in the long run. I can sometimes finish off a novel of 500-600 pages in one night. And I'm not skipping much. It's not that I'm skipping. It's just that I'm glancing through the page. But the story remains in my mind. So the connectivity to the story remains. Likewise, when you get a brief, you have to read it like a storybook. I find in every brief, in every case, a story. And that story comes when you read it in a correct way. So, it's very enjoyable. That's why I always say that I have never got bored in my profession for 42 years, nor have I got tired. Even today, if somebody sends me a brief at 8 o'clock or 9 o'clock in the evening of maybe 500 or 1,000 pages, I would be ready by morning. So it's very enjoyable. That's how it is. You have to love your profession.
So meaning thereby one has to be persistent and patient and
yes, absolutely.
Perseverance according to you.
It's a challenging profession. It can really bring many a times despair to your minds. So never lose your heart. And one most important aspect, always capitalize on opportunities in the right way. Because these opportunities come, very seldom in your career as professional. And if you can capitalize on those opportunities which come your way, then you can, march forward. If you miss out those opportunities, then I think those opportunities will never come back. And you must have goals. You must set goals for yourself that every 5 years or 10 years, what do I want to do? So unless you have goals, and then you don't strive for those goals, because if you set the goals, you'll be working hard towards achieving those goals. If you don't have goals, then you will just go into that, I think, run into the mill and not achieve excellence. So always set yourself goals.
Thank you, sir. It was a wonderful experience sharing with you. As I said that we will take these sessions, I have taken two friends of mine who have already come on this platform, and I assure you that we will take the arbitration. They will teach us on this thing. So participants who actually want to join, will ask a friend of mine, Tariq Khan, he writes frequently, and Anirudh from Madras. They write wonderfully. They have been writing articles on this bar and bench as well as live law. They have agreed to come on that. We will share with that. So a point well taken from you, that one should have a goal, or otherwise what we say in Hindi, he will be goal means zero in the profession. Tomorrow we have a session again in partnership with the ULS. That is Honorable Mr. Justice A.K. Sikri will join us on Constitution and Constitutionalism. That is at 6 p.m. Stay connected with us. You can like us on the Instagram and Facebook for the latest updates. I'm asking Professor Ratan Singh, who is the backbone for this entire process, who has encouraged us like anything. And actually, he helped us to, his name is Ratan, but he helped us to search you as a Ratan that you should come on the platform. Over to you, Professor Ratan Singh.
Thank you, Vikasji. Thank you very much. So, dear friends, you just see the food for the day which we have got from Mr. Dave. Because reason being, as he told at the outset, that the bundles and bundle cases are pending, and we have found out some other alternative mechanisms. And even that was not another alternative mechanism, that was another layer of judicial administration of justice. Reasons are why it was a failure, who is responsible for this, and how this can be a successful. Friends, the tips he has given to be a good lawyer, to be a good human being, and to be a good practitioner. Really, these are so wonderful, and these are, I suppose, being a student of law, that everybody is supposed to be admire this tips. Now, as far as the training part is concerned, I just want to quote and refer to Sir, that in my institute, we have arbitration board, and whatever the little we can train, we are trying to train to the student as far as the arbitration is concerned. And for this, we are taking the assistance from the bench and bar of Punjab and Haryana High Court. And the guidelines which you have discussed here, your suggestions are really workable and enriching our knowledge. And I hope this lecture will definitely be fruitful for me, for my student, for my institution, and for the next friends sitting here on this platform. So thank you very much for sparing your time and giving your valuable thoughts. Thank you very much, sir.
Thank you very, very much. Thanks to all of you.
Thank you, sir. Only for your this thing. We had joined live on Facebook for the first time. Probably you became the triggering point. Otherwise, we had never gone live on the Facebook. Thank you, sir. Thank you. Stay connected. Stay blessed. Thank you.
All the best.
Thank you.